I'll shut up.
We're getting all excited over here.
My, everyone looks good today. Wow. Congratulations.
Wow, that's
It's amazing what cold weather would do. Make you get dressed.
yeah. Man. I think Councilwoman Coonrod said she may be a few minutes late today. One, two. Who else we missing?
That'd be it. Well, we're missing Smith, I guess, but he's probably there listening.
Yeah, so don't say anything bad about him.
Okay.
All right, Nicole, I've got 2 o'clock. Let's go ahead and get started. All right, good afternoon, ladies and gentlemen. Welcome to our Tuesday, February the 16th strategic planning meeting. I now call this meeting to order. This afternoon, we have a couple of education sessions and one resolution that is going to be presented by Councilman Oglesby. So Councilman Oglesby, our first order of business is code enforcement education session. And that, sir, has your name by it. And you're muted.
I'm muted.
There you go.
Okay. Thank you, Mr. Chairman. Past few weeks, we've been talking about how we can do better with our code enforcement. And I know Councilman Gilbert brought up a matter about a way we can enforce it by possibly withholding future projects if they're not in compliance. So we've had extensive conversation on that, LDO and I, and Madam Clerk, if you would bring up Richard Beelan to get us started here.
Yes.
And then I think Mr. Sweeley would probably be needed also. Mr. Beelan, how are you, sir? Good to see you again.
Hi, Council. Good afternoon.
Good afternoon.
Great. Oh. Yeah, Richard. Oh, there you are. Okay, Richard, let's pick up where we left off yesterday, and I discussed and addressing something that this council brought up about the ability to get a tighter hand on some of the problems we have with lack of enforcement or people following in the proper procedures. So let's start off by addressing something that Councilman Gilbert brought up the past couple of weeks, actually.
Yes, sir. So Councilman Gilbert, it was our understanding that you had the idea that you could prohibit someone from getting a permit for a different project if they were still having issues on another project. And one problem that we're running into with that is we don't know if that's legal or not to do. And so we're looking to Phil to try to tell us, what direction to take there. So as we're doing that, we also identified a way to address it maybe with the permitting board or certification of one of the individuals that would have been in the project. So if you were able to withhold a certification from someone, and then they would have Phil, help me out here, then they would have the ability to appeal it. The process would be in place and there wouldn't be any kind of arbitrary decisions being made with that, then that might be a possibility too. But Phil, could you address just for the council the legality of withholding a permit from someone on another project?
Yeah, the concern is always whether someone on your staff is just arbitrarily denying someone the ability to get a permit just because they don't like them or they've not got their hair parted correctly that day. The issue should be an issue where somebody makes a due process determination of whether that person should or should not continue to do that. And that's what we were talking about, the aspect of having your boards at least more involved in those issues. You clearly have the ability where you have a plumbing contractor or a mechanical contractor who is doing a poor job to be able to suspend someone's ability to be able to get a license for a period of time if they're doing something inappropriately. And that board does that based upon the opportunity to have a hearing and an opportunity for the person to talk about what they have done and understand what they need to do for the future. And that has occurred for a number of years. There is an issue that is also available if you're dealing with a stormwater issue in connection with a construction project, where that entity would go in front of the stormwater board, and that board could suspend their ability to be able to get another permit for a period of time based upon their actions until they resolved it. But that results after there's been a due process opportunity for a hearing and action by the board and a record which can be appealed from that person. It's a little more difficult if you just have one person working in the city land inspection's office who says that your license is suspended for a certain period of time and you can't go on. That wouldn't give due process to that person. So I think that's a way to be able to do that if you're concerned about that, and allow the boards to be able to handle that where there are boards. One problem you have on the aspect of clearing land usually is that unless you have the Stormwater Regulations Board involved in those circumstances, the licensure board for most general contractors is over in Nashville. They're not licensed by our boards locally. We do license electrical, mechanical, plumbing contractors here within the city, for which they would have responsibility to our folks here locally. But otherwise, it would have to be a complaint that would be filed with the state of Tennessee licensure board over those contractors' licenses. So that's part of the issue that you have. Beyond that, you have the aspect of citations daily, fine issues that can occur there, and then issues of potentially filing an action if there is a continuing nuisance against that individual in court. And that's something that our office could help with if there's some concern about that. But those are the remedies that we understood.
Thanks, Phil.
Okay, we have Councilman Gilbert has a hand.
This question for Phil. Phil,
Yes.
Once the organization get fined and our people find that person, say $1,000, whatever it may be, what I was saying was that they cannot shut down that project and any other project till they pay the fine.
And I think that the Stormwater Board could do that, yes, in connection with that issue. If it is a fine that is involved, that is imposed by the court, then it would be up to the power of the court, and the court only has the power to, I guess, continue to issue that if there are multiple violations, and it would be up to us to file some type of nuisance action against them. If you got more, I'd say 2 or 3 violations of that group, we could do that to try to keep them from being able to use their license where they're causing constant violations.
And Phil, I'll say that LDO also has the authority right now to issue a stop work order.
Correct.
That exists right now.
And that would clearly stop them from being able to do that on a job where they're having problems with it, would not allow them to continue to do that. If you're wanting to stop them from all work anywhere in the city, though, that might be another matter. Can you use one job to say that you can't get a permit to do any other work? And that's where the problem comes in without getting some sort of court involvement.
I think my question was, until they pay the fine, they cannot work anywhere until they pay the fine.
I would prefer to be able to have a court tell them that they couldn't do that. As long as you've had a due process hearing before you allow them to do that, then I think that would work.
So you're saying they have to go to court?
Well, I'm saying we could go to court. Yes, sir.
And the court decide if they can continuation of their business.
Yes, sir.
So they basically doing what they're doing now, somewhat get away with not paying fines at all.
No, sir. I mean, clearly, if they owe us money, they are supposed to be paying that fine. They clearly on that job would not be able to continue work while that stop work order is in effect on that job. If you're going to try to cut them out of any work they might do elsewhere in the city, I would prefer to have some sort of court saying that what they're doing is an action that is inappropriate, and they should not be able to continue doing that based upon them having their contractor's license and using it improperly. And clearly the contracting board can do that as well. They can take their contractor's license away from them, but that's a little bit further away from you. That's over in Nashville. We want to do something that is here local.
Okay, I probably ask the other guy because I was trying to give the other guy tools so that they wouldn't pay attention to what they're asking to do instead of just going by day. I go, oh, fine, but I'm not gonna pay it no time soon. I'm not gonna pay it at all. That's what I'm trying to give them tools for that.
Well,
Yeah.
Jeremy's available if you want to bring him in
Mhm.
to discuss that, but we have the ability now to issue a stop work order. So if
Right.
someone's not paying their fine, then we have the ability to do that now, and we do that.
Okay, let's hold that thought because we got a couple more hands and then we're gonna I want to circle back to that. So Councilwoman Burge, please.
Yes, thank you, Mr. Chair. So Richard and Phil, I guess this is for you. As long as I've been on council, 3 terms, we're always talking about enforcement. And it's not just enforcement. I'm thinking about we're the legislative body. What is the problem that we can't seem to get our arms around? Do we need to rewrite our legislation? It could be this, it could be some of the short-term vacation rentals, it could be all of this. I can't believe that we're having all this problems with enforcement, and it can't just be LDO. So what are your thoughts about this? It seems like we're dealing more with people that are trying to get around things, and I think we need to have some serious discussion about that. So I'd love you guys' input.
I'm not sure of the enforcement problems they're having out there. Richard can tell you more about that maybe than I am. I know we have 2 people in our office that are going to court on cases whenever they're requested for city court violations on there. And I think there are issues going on. We may be having some problems in the COVID issues here recently, just simply because the courts haven't been able to meet. Luckily, after March the 15th, the Supreme Court has now said that those courts will be in regular session. So that'll help somewhat. But we do regularly have folks going back and forth, and I think citations and penalties are issued. I'm not sure about payment on that. Richard will have to tell you.
Well, I can tell you that the codes that do exist, we enforce, right? So if it's there, we're doing our best to enforce it. There are people that are always going to try to get around something, especially we in your district too, Councilwoman Burge, short-term vacation rentals. There are people that it'll pop up every now and then we'll address it. We'll take them to court, and it'll go away. And they're just they're operating under the radar in a lot of different places, and we're trying to address that. I will say that we've got one issue that Councilman Oglesby discussed with us yesterday is the $50 limit on fines, which is not local. That's controlled by the state, and there's nothing that we can do about that. And then on top of that, we also have the local courts who enforce that. So if we're able to issue a $50 fine, but the court doesn't back us up on that, then the person doesn't have to pay the fine. So, there are certain things like that are happening that, that are contributing to some of the behavior, I think, that we're seeing and continue to see.
I'm wondering, if I may, Mr. Chair, if we can, there's a lot of great minds on this council, and if our legislation or the way we're working it doesn't work, then it would seem to me that we ought to come up with something that does work. Otherwise, it's just a joke. It's like whack-a-mole. And the problem is that very often, particularly with the things that Councilman Gilbert's talking about, very often the damage is already done before we see it. And I know that LDO can't be everywhere all the time. And people are loath to complain because lots of times it's in their neighborhoods. However, if it's say the short-term vacation rental and a person's been caught once, what do we do? Just keep slapping their hands, or they keep paying $50? It's a joke. The other thing that occurred to me is, can we ever take any of these to Sessions Court?
Not on a city ordinance, you couldn't. If it is a state law violation, yes, you could. But if it is a city ordinance violation, that the jurisdiction is there with city court.
Well, the joke of the day is how do you beat city regs? And that's ridiculous. I'm just hoping, Mr. Chair, if
Mhm.
somehow we could sit down with and go through all of this. I mean, why even have these laws or these ordinances if they're a joke? And concentrate on the things that we really can do something about. Anyway, thank you very much, Mr. Chair.
Thank you, Councilwoman. Great points. I'm taking some notes here. Councilman Mitchell, I see your hand. You're muted, sir.
Thank you. I was actually going to go down the same road that Councilperson Burrs was going. I guess I got a couple of maybe specific questions, but I think she's absolutely correct. It seems like there's a disconnect between punishment to get people to comply and just us going about our day-to-day business of here's a fine, we'll go cite you to court, and whatever the judge does, the judge does. But Phil, you were making a comment about you want the courts involved if the storm, if it gets out of the purview of, let's say, a stormwater board or something like that. You would rather have a due process like the courts involved. Are you asking at that point that, or are you making a statement that we need a law to be able to get courts involved? And I guess it goes back to what Councilperson Burrs is saying. If we pass a law, it's city court and not sessions court, where the punishments and things can be a little more costly, and people possibly would pay more attention to what their actions have caused. So are you saying that we need a better law or a law period, or what are your suggestions, I guess?
Well, anytime you have an independent board, that helps in that regard, because there's a body other than just the person who is issuing a citation that's making the decision. So there's an argument that there is clearly due process by a body, just like this council hearing decision making on issues involving short-term rentals. There's a body that's making a decision. There's an opportunity for someone to appeal, and it can't be argued that that one individual that gave the citation is just arbitrarily doing that. So that's a good thing to happen anytime you have a review of someone who is just an administrative official by the body. So we do have that clearly under stormwater boards. We do have that whenever you get someone to a court session. The problem we have under state law in that regard on the Constitution is that if it is a citation to a court and it does not have the ability to have a jury trial, then that fine can't be more than $50, which is in the Tennessee Constitution, which is really very strange. It's been there since 1797. It was almost overturned here a few years ago, which is just ridiculous that we're still dealing with those numbers. But if you have a court where there is the ability to have a jury trial, then you can go forward. That's what I was saying, that you might be able to have some type of nuisance action filed against the real repeat offenders here by going to a different court other than just city court. And we have done that previously whenever we're dealing with issues about, I guess the Club Fathom is one that comes to mind here when we were having problems associated with that, about getting something to close down the business. And we can try to do that if we've got really bad repeat offenders.
Would we need something that would more clearly define nuisance as it relates to the construction industry?
I would think you'd have to have multiple violations by a particular vendor here of the same type of violation or similar violations that have occurred. Whenever you've got that, then that would be something that you could take further and go to a different court.
But would we need a new piece of legislation to be able to go down that road?
No, sir, I don't think so.
Okay, all right.
Yes,
Thank you for now, Mr. Chair. Thank you.
Yeah, thank you, Councilman Mitchell. Councilwoman Burrs, Councilman Ledford is coming up, but I would love to circle back to you because I saw that you might have some further discussion. I want you to feel free to do that. So if you don't mind, Councilman Ledford.
Go ahead.
Yeah, Councilman Ledford, your hand, please.
Thank you, Chairman. So, Richard, quick question for you. What triggers the stop work orders, and how is that trigger mechanism created?
And I'll bring in Jeremy for this to answer that properly.
Sure.
Councilman.
Yeah, no worries. And then Phil, I'm going to throw one at you. You could be chewing on.
Oh, sure.
I have stood in front of BOZA to clarify intent on changes that I've made to height restrictions in C4 to allow for development of buildings taller than 35 feet, which has proven to be a good economic tool and a much needed change. What mechanism, Phil, do we have to go to city court to clarify any misconception or intent when we actually do create an ordinance and to help clarify our position, state our case, so to speak? That would be one for you to chew on for a moment. Going back to Richard. What triggers, she's saying she doesn't see Jeremy in the list.
Yeah,
So the question, Mr. Chairman, is who makes up the list, or what triggers stop work orders, and can that be done through ordinance by this council?
And Councilman Dallas Rucker or Charlie Young are also available.
Yeah, anybody who wants to answer is fine. I'm just trying to figure out when that box needs to be checked, who's making the boxes to be checked? Can we do that on our end?
and I don't see Charlie.
Trying
I'm
to-
here.
Charles Young.
I'm,
Got his hand up.
I'm here.
Got Dallas.
Dallas.
Okay,
Dallas, can you answer that one for me, bud?
The first stop work order would be issued just to the site contractor himself, or if, say, the site contractor's gone and the general contractor takes it over, we would stop any dirt moving or anything like that on the outside of the building. After 7 days, if they haven't corrected it, we will issue a general stop work order so that as I said yesterday, the painters, the electricians can go all help the site contractor fix his erosion controls or take care of his issues there. We'll stop the whole job. But that's what we've been doing.
The list that we have, though, Dallas, that you're working off of, the items that trigger the stop work order, who creates that list? Those requirements to engage in a stop work order.
The inspectors themselves.
So the inspectors
They're there every
individually,
day. They keep up with the time they issue a notice of violation that says, hey, you got a problem, you got a little time to fix it. Then we stop work, or the correction notice, which is basically a stop work. It says you can only work on the problem that we have. And then at that time, after that 7 days runs, if they haven't finished it, that's when we'll stop the whole job. But the field inspector himself is keeping up. Is that what you were asking?
no, I'm gonna try a different way.
Okay.
So when they're out in the field, an inspector, they're working off of a list of items that they need to be looking for.
Oh,
And
okay. Yes.
They see item 5 or 6 or 7 on the list. Who creates the list for a stop work order?
Well, that would be part of the notice violation. The inspector would put those things, the list that was a problem, or the things on the list that were a problem, in his notice of violation. Or are you asking, now maybe you're asking who creates the checklist?
Yes.
Now we're
The
cooking, bro.
checklist
Yep.
is created.
Now we're
Checklist
cooking.
is created by Jeremy and his inspectors,
Okay,
and Tony
Now-
Kinder, when he was there, he
okay.
kind of
So
had
that,
the final say on the checklist, but it basically mirrors the ordinance.
okay, maybe that's where we need to take a closer dive, is to see if the two are jiving together, so to speak, meshing, if you will, and see if, and working through legislation, I can tell you, I would much rather LDO come to us with a solution or an answer or identifiable misstep or something that we can work with versus trying to go at it from our point of view, because you can see the questions that we're asking. So, Mr. Chairman, I would just respectfully ask that maybe we we ask LDO to come up with a top 10 list, if you will, of items that they think that could be researched, and we go through that list and see where the belt could be tightened or maybe redefine some of the items. I appreciate that.
Yes.
Phil,
Council, oh, I'm sorry.
that's okay. Phil, can you answer that question I threw at you real quick about interacting? I know you said we don't, and I understand the differentiating different branches of government, trust me, but I've stood in front of BOZA and made my intent known and clarified when they've actually asked questions. Will you please clarify why you changed the law? And obviously with the help of this council. But is there a way for us to help clarify our intent when we are actually write a law so that there's no misconception as to what we were trying to go for?
Yep, clearly, anytime you're making ordinance changes, we need to make sure that the courts, if the courts are enforcing those, that they get a copy of that most recent ordinance change. Our office will help in that regard, making sure that the judges have that most recent copy if it's something involving an issue coming before them. If it's an issue in front of the Storm Water Board, which, and I think we've got a little bit of disconnect here. You know, construction goes from the point of actually starting to flatten out the land and to change things all the way through the actual finished part where people have to comply with the uniform codes that we have in effect for construction. So we have a number of uniform codes for dealing with plumbing, mechanical, any type of work that is done inside that structure that there may be violations of. And Dallas's people will give a notice of violation if it's not done in accordance with those uniform codes. But we also have the aspect of whenever the property is being graded, and that appears to be one of the bigger issues with neighbors here when you're doing stuff in infill in close-in neighborhoods. And so those issues are situations where you've got removal of trees off of the land. You've got issues where there are, hillsides that are caving in. Those are issues that have to be dealt with as well in a different manner. And whenever that's going on, there's got to be an immediate stop, or there's got to be a remediation that occurs. And that's where Jeremy's people come in regarding silt fencing and things like that as it goes along. But we got different variations, and it's in a situation like that where there's a major problem, that may be a situation where we need to go to court immediately because there is an emergency going on under those circumstances.
Okay, and maybe even legislation that's brand new and groundbreaking, pardon the pun, that makes us stop and take a few extra steps when looking at a steep slope to take a breath and maybe take a look at vegetation standards that don't exist. Had to throw that in there. Thank you, Mr. Chairman.
Yes.
Thank you very much, Councilman Ledford. We're going to go to Councilman Byrd. We have not heard from him, and then we're going to circle back to Councilwoman Byrd. So you got the floor, Councilman Byrd.
Thank you, Chair. Phil, what I just heard, I'm just trying to get some clarification.
Yes.
If a local inspector creates the checklist, okay?
Right.
And this can be for Richard as well. If a local inspector creates the checklist, who gives the local inspector the authority or the power to shut that site down? Who gives that local inspector that authority?
Normally, their authority would be coming from the codes that we are enforcing. You know, if we have an issue from under the manual on, I guess in this case, like an electrical code issue or a plumbing code issue where it is a health and safety hazard, there are violations that they can list in connection with that, and it can't be operated until it's corrected. They normally would give a specific amount of time that their manager would allow them to do to correct that problem. And if it's not resolved within that time frame, the manager would then say that you're going to stop work on the job until such time as that is corrected. But that's my understanding of the process. Richard can confirm.
So the building code is going to set out what the requirements are for our building, right? So if you're going to go in and review something, our code already says that in there. We've adopted that code that says you must do this or you must do that. If you're not doing it, then the inspector is going to give you an amount of time to do it in. And if you don't do it within that amount of time, then they're going to shut it down. Ultimately, they can withhold a certificate of occupancy as another tool to be able to address that. Some of the stormwater regulations that Phil was just addressing are set out by TDEC. And so once, if those aren't followed or if they're not following those, we also give them time to rectify that. And then we can issue a stop work order until they get that done. So it doesn't necessarily come from a checklist by each individual inspector. It all comes from codes, which we've adopted through the building code or from TDEC for stormwater regulations.
All right, Richard, I guess this is what I was trying to get to. It seems like a lot of times, Richard, like we'll have a conversation about a whole bunch of things that kind of don't add up sometimes. And this to you too, Phil. I'm kind of piggybacking off what Councilman Gilbert said. Why can't this body just say, if you have these fines outstanding, or if you have this in the city of Chattanooga, this body has voted unanimously, if you have these fines in place, you can't do business in the city? Why we can't just make that plain and simple a piece of the law of Chattanooga? This is the law in Chattanooga. If you have this violation or if you have this issue, this body has voted to say you can't do work until you take care of this situation.
Well, I guess the problem comes that they actually have, or some contractors have a license that is issued by the state of Tennessee to do work. It's sort of like the TWRA coming in and saying that there are certain things you can make regulations on in the city and some things you can't when it involves bird hunting, for one thing. That's one of the issues we've gotten into in the past. If there is a license that has been issued by another entity and you are prohibiting them from doing that, it could definitely be a problem. If we can establish in front of a court and an issue in front of a judge that this person is really doing it in an improper manner, then that's another matter. That is a public nuisance that we can rectify. But unless you can establish that and have a judge determine it, I think that's where the problem is.
So it's almost like, Phil, our laws and this body has no power. Like, it's like we're sitting here as just some pawns, just sitting here saying things, and we have no power to enforce. At what point does this body have the authority to really stop or shut something down? It's like, I don't know. It's kind of crazy, Phil. It's like we have no authority at all. Every time we try to say something or put something forward. And Russell, I like what he's saying, that we should be able to stop. If we can hold you up because a local inspector that has this list says that if you didn't do X, Y, Z due to these criteria, we can stop this project. They can say, well, I'm gonna keep working. What you gonna do? We can't put them in jail. We can't go down there. What you gonna do? We're not gonna give them electricity. We're not gonna give them water. It should be something that this body should be able to put in place without having to go through all the procedures of court to get a reasonable answer for our communities.
You clearly already have the power to shut the power off if there is an electrical violation that is occurring on the property, but it's not allowed for just not paying your bill. It is a situation of the EPB can shut your power off for not paying your electrical bill, but the city can shut it off for a safety hazard concern. Same difference for a plumbing issue that is out there. If there's a plumbing concern that's going to cause a health and safety risk, they can shut off the access to the system. But that's the power we have.
But we just can't shut you off as a city council. We can't put something in place to shut you off for doing improper work because you have a license held by the state. That's crazy.
You could, but you would also be potentially sued for that because someone would argue that you're doing that for an improper reason, just because you don't like them or because of what they've done. If you have an ability to have a judge make that determination, you are much safer. And that's what my legal advice would be to you.
I understand. Thank you, Phil.
Yes, sir.
All right, thank you, Councilman Byrd. Look like we're going to be circling back, but I got an idea. Councilman Byrd.
Thank you, Mr. Chair.
Thank you.
Phil,
Yes, ma'am.
let me make sure. You're saying that city ordinances can only be heard by city court unless it's egregious enough for a long enough time to become a nuisance, and then it can go to Sessions Court.
It would actually go to either Chancery or to Circuit at that point in time. Yes, ma'am.
All right. So, okay. So I know this is going to sound a little ridiculous, but all of these ordinances that we make, dozens every year, that have to do with some sort of specific performance, somebody doing or not doing something, are only worth up to $50, which is a cost of doing business. Is that what you're
Per
saying?
day of violation. Yes, ma'am. There is a per day violation charge on that amount. And it's really only as good as the character of the people who are doing the work with in the city. That's the
All right,
bottom line.
so it's $50. The most it could be is $50 a day. I'm
Yes.
talking about across the board. We pass ordinances all the time, and LDO, there's a whole list of things that would fall under their enforcement. And really, if they did everything perfect, which they do a lot of good work, the most anyone would be fined is $50, or if it's $50 a day, they have to run back out there and prove it every day. It can't just be an assumption. Or if it's egregious enough, which is public nuisance is very hard to prove. Look at some of our bars and stuff, which terrible things have happened and they're still going on. So actually, as a practical matter, it seems like all of these ordinances that we pass for the quality of life for our neighborhoods or good and welfare for our community really are useless, because anybody would use it as a cost of doing business, and $50 is well worth it. I think it's finally hitting me. That's what you're saying. And that's why that's why I'm trying to figure out why we as a legislative body, and unless the bottom line is it's all illusory and we can't do anything because the state has preempted us, that when we pass these things for the good and welfare of our people, for good intent, okay,
Yes.
they're pretty much useless, right?
I won't say they're useless, because I think that in the great majority of people are willing to comply and try to do the best they can. It's $50 for the fine. It's also a cost of going to court. It is the hassle of having to deal with that issue once someone has been cited and having to deal with that problem. In these times, they don't really know the certainty of a date when a hearing will occur. All of those may or may not cause someone to comply. But
they're going on continuing doing their thing. And I'm not just talking about a stop work order, whatever it is. They're going on and doing their thing until they go to court. Court costs aren't always collected, nor are fines collected. As one of my rather dubious constituents told me one time, Councilwoman Burrs, tell you what, I'll pay you $50 a month. And I'm going to go on doing what I'm doing because y'all don't have any teeth. Actually, I wanted to argue, except he was probably correct. So is that what you're saying? I hear you. It's not the people that are doing the right thing, Phil. We're dealing with the people that are slimy, trying to get around things. And so they are. Is that correct?
Yes, ma'am. And anything we can do to get the slimy folks to do things better, that's what we need to try to center on. Yes.
Can we pass legislation effectively that will do that? Or are we preempted by the state?
As long as you're not dealing with the aspect of taking someone's livelihood away without a hearing, I think you can do that. You could order those folks to appear in front of this legislative body if you wished to do so, have some kind of record of what type of hearing you gave them. If you were wanting to do that, that's one possibility, but that's really what I'm.
So we could be the hearing. We could pass legislation saying, you're coming for us, dude, because you don't want them to follow the law. Okay.
Yes, ma'am. And y'all have already done that in connection with a number of his permits that you have, that they have the last opportunity to speak in front of this body.
Thank you.
Yes, ma'am.
Okay. Hold that thought, Phil, for when we have a conversation like tomorrow, okay?
Sure.
Chairman Henderson, please.
Thank you, sir. This reminds me of Jerry Clowers when they was coon hunting and they got a lynx treed and they just they couldn't turn the lynx loose or and they just said, shoot up here amongst us. Somebody's got to have some relief. Phil, I've sent you.
I'm catching a lot of the shots today, Chair.
I have sent you an email that Jeremy Sweeley sent all of us back in June of last year.
Yes, ma'am. Yes, sir.
It's some great recommendations on anti-recidivism, new enforcement protocol tools, all of this that he gives and lays out very well. Most of it involves legislation. Phil, this is my question. You keep referring to a state license,
Yes.
Contractor's license. But if I have an unpaid business license in the city of Chattanooga, I can't pull a permit. So,
You would have to have a business license. Yes, sir.
but my point is this, it's an unpaid bill that the city of Chattanooga prevents me from pulling a new job permit. I don't understand the difference between that and if I have unpaid stormwater violations, why that would prevent us from allowing a contractor from pulling a permit on another job. To me, it's the same, it's an unpaid bill.
And
So
in my mind, yes, sir. In my mind, if the Stormwater Board makes that determination that you are owing an amount, you've not paid that amount, and they tell you that if you don't pay that amount within a specific time period, then you can't do another job, then I think that's fine. You've had an opportunity.
Okay, stop
for it more.
right there. Are you
Yes.
saying the Stormwater Board needs to come up with a code, or what is it that Stormwater comes up with, Richard? What do they produce? They don't produce legislation. What is it they produce?
The thing that I think they produce is they have the ability to be able to hear what the stormwater manager has assessed, has made a determination about what fees are involved, and there is an appeal to that board for anything that has been issued by that stormwater manager. And if that person has issued a fine or a citation against that body, and they do not appeal that amount, I believe that might be your remedy here that you're looking for on land development.
Okay, on this particular issue, and this is what Councilman Gilbert, I think, is getting at. How do we prevent contractors, developers from continuing to do business in the city of Chattanooga with unpaid stormwater violations? Is that correct, Councilman Gilbert?
That's correct.
That's the kind of the crux of this matter, at least. So are you saying that the Stormwater Board needs to come up with something that would say you can't do business in the city of Chattanooga if you've had an unpaid stormwater violation for more than 60 days or whatever? Is that what you're saying, Phil?
Yes, sir. And I was looking right before, because I didn't know if this type of question would be asked. They have a hearing procedure under Chapter 31 that allows them to do that and to be reviewed if there's a problem. I think they could do that in connection with that.
But you're saying that this body needs to call on the Stormwater Board to enact whatever it is they enact. I'm not even sure what you would call what they enact. I know they passed a stormwater regulation. Is it regulations that they enact?
Yes, sir. But there is a procedure for how that body acts under Division 8 under the code. And it says in there what types of hearing procedures they can have and what type of review. It gives the ability of that board to make a hearing and then make a determination. I think if you included that as part of their powers under there, you'd be okay.
Okay. Make a hearing.
Mr.
Make a hearing. Go ahead.
Chair, if I could, I think that at the very beginning, we were talking about what we don't know, and that's part of it. And so if we can create that, or if we can have the Stormwater Board create that to address stormwater related issues, then we can do that. But that's why we're saying, is it legal? And Phil can let us know of that. Back to your point about Jeremy's email, there are some things in there that we think that we could probably do as well. But I think we need to bring them back to you as a board to see if that's something you are willing to do. And so we could look at that as well. So that's the two things that we would be able to do at that point. And then there are some ordinances that we need to address potentially that would create or correct some of this or give us more teeth to be able to address some of the issues. And that's something that we could look at as well. If you would be willing for LDL to bring that back to you.
Yeah, well, yeah, absolutely. That's all in the email from Jeremy dated back in
2019, I believe.
June 4th, 2020 is what I have on here, but he's got, I mean, he's got 4 things laid out, 4 attachments laid out. They're great. They're every one of them's hitting on all cylinders. And I guess the first thing, Phil, then direct this council. What do we need to charge the Stormwater Board with? I mean, is this a resolution that this council needs to present to the Stormwater Board?
I think in part enabling the Stormwater Board by ordinance to be able to have powers to have these hearings. If there's something that you want them to develop protocol, we can include that protocol within those ordinance provisions where they would look at that in a hearing and then issue those types of fines. If that's what you want to do.
How soon can you get us an ordinance back?
I have got Jeremy's stuff as of February the 12th. I didn't get it back in June of last year, but I got it. And if you'll give me a couple of weeks, and we'll have it for your next strategic planning.
Well, I'm just talking about, first of all, just the first one. You said enabling by ordinance to have a hearing that would prevent a contractor from pulling a permit on another job with unpaid stormwater violations. Get us an ordinance in front of us at next strategic planning.
I can do that. No problem.
Thank you, Mr. Chair.
Thank you, Chairman. And the next date, which would probably be around March the 9th. So let's shoot that target date.
Yeah, that's right.
So we can, have some time frames so this thing is not lingering out here. So
well, feel free to get it in front of us before then.
Right.
But we can talk about it.
Oh yeah. But the next full discussion would be on that day. But yeah, if you can get it like Friday, that would be great. But
all right,
we'll have some more conversations because we got several things clicking here that's very important.
I forwarded you Jeremy's email as well, Phil.
Yes,
so
sir.
That you can go over all that.
Yes, sir. I got one on February the 12th, so I have a copy. All right.
Okay.
All right. Thank you for your patience, Councilman Gilbert. I see your hand.
Yes, this is for Phil. Phil,
Yes,
you made a statement saying that the state almost passed the $50 fine to be more.
Yes.
Can we not work with our state representatives or senators to suggest that to have a range? Because I believe the rural areas are the one, and we got more rural areas in city inside Tennessee.
Yes.
Can we have a range from 50 to X? And the city itself can choose from that range what they want to have for their city.
Yes.
Can we not do that? Because to me, it makes sense. You still got $50 there for whoever wants it. But if another city wants to increase, they have the ability to do it based off the state approving it.
Yes, sir. And our ordinances used to read that it would be up to $500 for each offense, but the Supreme Court's, the ruling of the Tennessee Constitution prohibited that fine to be that large. If they would give us that discretion, I think you'd have tremendous help on municipal violations if it could be up at least $500.
I can't see no state person saying no if we left it for choice. $50 to $500, your city choose what you want to do.
Yes, sir.
I can't see them saying anything about that. That would prohibit from doing that. Can we start doing can council do a resolution that suggest and start working with a state representative and a senator to present this to the rest of them?
Yes, sir. I think we may have had something previously for that. I'll find you a copy and we'll get it back to you.
Okay, thank you.
Yes, sir.
Okay, thank you, Councilman Gilbert. Councilman Ledford.
Well, I want to thank the chairman for his comments because I feel like he was reading my mind about moving forward with a resolution for action on the Stormwater Board. So I don't believe everything I read on the internet, and neither should anybody, but in 1797, $50 was approximately 1,500 is what I find as a quick search, just to kind of put that into perspective. Thank you.
Okay, Chairman, I see your hand up again. Is that a new hand or old
No,
hand?
sir, I failed to take it down. I've said my
Okay.
piece.
Okay, I see no other hands on this matter. I believe we have our marching orders. Phil, Richard, at some point, I want to just touch
Chairman?
bases for a few minutes to make sure we are on time and headed in a direction where we can get the results that this council is expecting on this matter. So thank you all. Councilman Ledford, is that another hand?
Yes, I'm sorry, Chairman. I just wanted to
It's
touch
okay.
on the $50 fine real quick because I've had conversations with state senators about this. It is in our Constitution, which means a constitutional change, and the voters of the state of Tennessee would have to change that. So there's that.
Okay, thank you. Thank you for that, Councilman Ledford. Okay, I see no other hands. That's all I have for this matter, Mr. Chairman.
Okay, thank you, sir. Madam Clerk, would you dismiss our guest? Thank you, gentlemen, for being with us.
Thank you.
All right, Councilman Oglesby? I
Yeah,
think the next matter is yours as well. Resolution for non-owner occupied short-term vacation rentals. We ready for
Sure.
that?
I sent a copy to everybody, I believe, yesterday. It's short and to the point, giving LDO and RPA the authorization to look at this. So if it's the pleasure of this council, I'm requesting that we put it on next week agenda for vote so we can move forward with this. And it's simply giving them the authorization to look at some standards for density and some other matters on how we look at let me make that clear, non-owner occupied short-term vacation rentals. If there's no objection.
Yeah.
That's a yep, like let's roll with it.
I'm not hearing any objections, sir.
Okay,
Let's get it on the agenda.
okay. Thank you very much, Council. Thank you, Nicole.
All right,
That's all I have.
okay.
You want it on 2/26 or when? I'm just trying to make sure.
Yeah, whatever next week is.
Okay, all right, I'll get it.
Thank you, Phil.
2/23, I guess.
That'd be
2/23, yeah, whatever next week is.
Okay, I'll get it.
All right, council, let me ask real quickly, I should have taken care of this at the very beginning of our meeting. Is there any council person that would be needing a attorney-client privilege meeting this afternoon after strategic planning?
I don't.
Okay.
Mr.
Nobody?
Chair, I'll need one for next week. I have a case I need to talk with you about, but not for this week.
Okay, that'll have to be after our 3:30 agenda then.
Yes, sir.
Since we don't have strategic planning. Okay, so very well. Nobody needs an attorney-client privilege for this afternoon. Okay. All right, very well. All right, under other business, pending presentations and education session, I think Councilwoman Coonrod, she's not here, I think is asking again for another YFD committee meeting to talk about, again, the Office of Family Empowerment. And I think just an education session on what they're doing and how they're handling the LAHEAP funds. Any questions from the council about this? Okay, we'll just wait for Councilwoman Coonrod to bring that up. All right, under pending legislative matters, steep slope vegetation component, Councilman Ledford.
Chairman,
I've been waiting all afternoon for this.
Chairman, what you have is a proposed ordinance, and given the conversation that we just had, I hope that will be a benefit to our city. And as it has been determined already by previous conversation, I'm going to add the nickname to this, the $50 steep slope vegetation component. So I want to take that into perspective now that we've had that cleared. When we see a lot of issues or what it doesn't address or what it does address, I want people to keep in mind we're talking about a $50 fine now. So what you have in your inbox is a proposal that helps to steer the direction and mindset of how we look at steep slope development from the very beginning, and how we move forward and define what a steep slope is. I want to really give a shout out to the staff for their recommendations. I have personally gone through that list, and I will be providing responses to that list in your packet today. I have answers for almost everything, including a compromise on the percentage of defining steep slope. If it's 33%, fine, it will go 33%. I don't think that's going to be detrimental. What I do think is important is we address, first of all, this is a post-construction, and some of the comments are from staff is that it doesn't solve all of our problems. Well, it's not designed to. Quite frankly, it's not designed to. It's not the magic pill for all of our steep slope woes. It is a vegetation component that helps. Well, first of all, we don't have anything, and it's better than nothing. Had this been in place 15, 20 years ago, some of the problems that we have had might have been mitigated or not even existed. So it's better than nothing is what I'm trying to say. It puts into place vegetation components that do not exist. And if it takes a little extra work, then I'm okay with that. I think the people of Chattanooga deserve a little bit of extra work when it comes to looking at steep slopes. And I do look forward to talking about the pre-construction and the on-site construction components, which we have assigned to ECD. So what I would like to ask council is take a look at the staff questions, try to answer them the best you can, get those to Phil, and let's try to do something good and something that's different. Instead of finding and poking holes at this, which seems to be legislation process, let's try to find the good in it. And let's put something into effect that actually might make a difference and move us one step closer to doing something that has tremendous impact on how we look at steep slopes and developing. And who knows, maybe this is a catalyst that will stir a lot more creativity and open dialogue. Chairman, I rest.
We do have a couple of hands, well, myself included. Councilman Mitchell? Unmute your mic, sir.
I got it. Thank you. Thank you. Phil, if we somehow got this, and I'm going to take the blame for something, we're just calling it steep slopes, and that's what this is addressing, steep slopes, but we started down this pathway for steep slopes and floodways. So not saying we want to introduce that right now. If we want to go and just take care of this part of it right now, that's fine. But if we were to put this legislation somehow under the stormwater section, we're not talking about a $50 fine. We're talking about the ability to fine much more, right?
Yes, sir.
Okay, that's all I wanted to know. Thank you.
Yes.
Councilman Mitchell, that was exactly my question.
I saw it on your card.
Great question.
Yeah, and I think Attorney Noblett answered that. So I think that'd be a very appropriate place to put this so that we're not talking about a $50 fine. I think the discussion that we've had today has been very enlightening and probably leading us to think a little further down the road. All right, any other questions about this ordinance? Councilman Ledford.
Chairman, if you don't mind, Phil, would you please look at the section 38-603? Can you make those changes that staff had commented on versus the draft language versus staff comments? How can we get those comments altered into this proposal so that quells their concerns about inconsistencies in language and or inconsistency with other parts of our city code. Can we do that relatively quick?
Yes, sir.
Oh, I'd like to hear that answer. That's awesome. Okay. And then that eliminates like 2 whole pages of comments. And then that leaves us with, I think, 1 page we could kind of address from there. And I do plan on addressing those this week with some of the, for some of the questions. So if council will take a look at that first sheet, page 1 and page 2, and concentrate mostly on that, we will then we'll move forward with the city attorney with the staff comments in the language section. And then that should move us 1 step further, I hope. Thank you.
Okay, my next question is to Councilman Ledford and Councilman Oglesby. Do we want to hear this in committee on the 9th? Or do we want to take a stab at this at strategic planning first? What, Councilman Oglesby, your mic is muted.
I would take a stab at strategic planning first and then follow up after that.
Yeah, I concur.
Okay, so let's, council, do we want to, since we are not having a meeting on the 2nd, do we want to treat the 2nd week as our first week and have strategic planning on the 9th? There's actually 5 Tuesdays in March, so we could do the 9th and the 23rd for strategic planning. Is there, let me just put it this way, is there any objection to having strategic planning on the 9th and 23rd?
No
That's
objection.
that's
I have none at all.
okay. So Nicole, could you notice that to the public?
Yes.
That this is a little different than our typical strategic planning weeks, in that we're going to do the 2nd and 3rd week instead of the, I'm sorry, let's see, 2nd and 4th week, 2nd and 4th week.
Yes, I can advertise.
Okay. If you'll notice that so that we will be legal. Then also put on your, and let's not try to load down strategic planning on that night. I'd like to devote the majority of strategic planning to this piece of legislation. Councilman Oglesby, will you be handling that, I guess, under ECD, since that's where
Yes.
this ordinance will lie? And then
Yes, I will, Mr. Chairman. I'll handle it under ECD.
And then have the appropriate people there that, we might want John Bridger there, Dallas Rutger, maybe Donna Williams would be appropriate.
Sure.
Okay, all right,
Mhm.
very good. Councilman Mitchell.
Yeah, as a point of, well, not really order, reference, the stormwater folks are in Public Works.
Yeah.
Now, I'm not saying I want to move it to Public Works out of ECD, because there's a lot of LDO participation and many other things that we're going to be talking about in this. I'm just saying that, if we need Swilly at least, and some stormwater folks in on that meeting also.
I agree completely. That's a great point, sir.
I'll be happy to share that day with you, Councilman.
Okay, sounds great.
Yeah.
I'll tell you what, Councilman Mitchell, then why don't you make sure that, I guess Bill Payne is available,
Okay,
and whoever
Bill wants to bring.
whoever the appropriate appointees for stormwater would be, because I think I would like to see this reside in stormwater so that the fines can be appropriate.
Sounds great.
Thank you.
I'll be sure and work on that. Thank you.
Okay, all right.
And Councilman, it won't be deliberating team, but Councilman Mitchell and I will be practicing this to make sure it goes well.
I think that's a great idea, sir. Okay, also under pending legislative matters, and we talked a little bit about it earlier, was our LDO enforcement tools protocols, which we've forwarded, and the attorney said he does have And it might be entirely appropriate, Councilman Oglesby, to hit on that as well, as we work through the legislation that Councilman Ledford is bringing to us.
Mhm.
Okay.
Yes,
All right.
sir.
Very good. Now we move down to board appointments. We do have a couple of, we have Board of Sign Appeals, Board of Zoning Appeals. Madam Clerk, I haven't noticed before that I have, is my appointee for Board of Zoning Appeals, his term expired?
Yes, I don't have the name of that individual, but if I believe all the ones that listed, those were expired.
Okay. All right, very well. All right, let's move down to B, group nomination process. Now, I think under number 2, the Industrial Development Board, the 2 seats that are up for reappointment have agreed to stay on until we get through with the process of going to a 9-member board. So I think that we're good there on in IDB board appointments. I think the board that we do need to look at is our HEH board, which does have 2 seats vacant that we do need to address. And I think 4, 5, and 6 would have an appointment, and then 7, 8, and 9. Madam Clerk or Mr. Attorney, I don't know that it matters which group goes first at this point. I guess whoever gets their board appointment ready for a nomination. I mean, is there any reason we would need to take 5, 6, and 7, or 4, 5, and 6 if 7, 8, and 9 had theirs first?
As long as you fill those 2 seats so that you've got the ability, I don't see a problem. We are also, this coming, the 24th is going to be the Health and Ed Board meeting. And at that time, I've got on the agenda for them to authorize the charter amendment that will go to the Secretary of State for a 9-member board. So that's on the agenda for the 24th for that board. And it will be on the IDB board's meeting at the beginning of March.
Thank you, sir.
Yes.
So districts 4 through 9, if you would get in your collective groups and come up with a nomination as soon as possible and present that to the council. Any questions or comments concerning the HEH board? All right, I'm seeing no hands at this time. Okay, let's see, what we're coming up on the 3 o'clock hour, and we will need a little break before we go to our 3:30. Is there anything coming up, and we will cover these during our 3:30 agenda session, but anything on the agenda tonight, next week, or future considerations that you'd like to throw out at this time? Councilman Ledford.
Chairman, question for Mr. Noblet. Did we get the alternate version or the changes to item 0008?
0008.
Yes,
sir, I believe so.
6A?
I believe those were done this afternoon on the last draft on there that they were requesting on there, and that was the reference for I guess a stormwater and sewer provision in the code. We got that change made, I believe, for the last version.
Okay, is that going to show up as an alternate version, or is it just a?
I think it says alternate 2 on there, but I know that's what it said on the version I was looking at. I haven't looked at the agenda version of it yet.
Okay, I wanted to ask because I didn't see Councilwoman Coonrod here, so I wanted to make sure she was covered on that item.
Yes, sir. Made that change earlier.
All right, thank you, Chairman.
All right, this afternoon, committees, looks like we have economic and community development. Is that correct, Councilman Oglesby? Okay, I read your lips. I believe you were confirming the fact that we have ECD meeting.
I was confirming it, Mr. Chairman.
And then on the 23rd, Councilman Mitchell, we have Public Works and Transportation.
Yes, sir.
Did we or have we covered our rising stormwater and sewer treatment bills? Councilman Mitchell?
I'm sorry, Mr. Chair, what was the question?
I'm getting some questions from constituents about our sewer bills consistently or constantly going up. Have we discussed that in the last little while?
We had a discussion last week about stormwater, but I don't believe we bills, but we didn't, I don't believe we have, that I can recall, I could be wrong about sewer bills.
About sewer?
You want to
Yeah, I think
in next week's committee meeting?
would you, sir?
Well, I'd be glad to if you ask. You've asked, so that's consider it done.
Okay, thank you, sir.
I'll move Mr. Payne right into that.
Very well. Anything else that needs to come before the council at our strategic planning agenda this evening? Okay, I'm not seeing any hands, so I will see everyone back at 3:30.
Thank you.